This is my 6th year presenting at Denver Startup Week, and for those of you who have attended other sessions today in here, thank you for coming back. I know 3 hours of legal presentations are not always the most entertaining, but we'll do our best to keep you on your toes here. So I'm going to be presenting today on a presentation I call Putting the IP into Hip, and you can see I've got these thick rimmed glasses here. I'm wearing some of those, so we're getting hip already. So let's dive in. I want to make sure this is really valuable for you guys, and I know there's a lot of different considerations. So I'll go through my whole presentation. We'll talk about all the different types of IP, but I'll definitely reserve a good amount of time at the end for questions, and want this to be a really valuable resource for y'all. So starting off, once again, got to thank our sponsors here. We got Amazon, Capital One, Dell, Denver Business Journal, Downtown Denver Partnership, Public Works, Battery 621. Excuse me, and once again, thanks to Greenspoon Martyr for hosting us. More thanking of sponsors here. All great folks. Contractually obligated. And then our little legal disclaimer. You guys have already seen this if you've been here before, but I am not your lawyer unless we have officially achieved engagement, which we haven't. So everything I tell you here is kind of for educational purposes, and there is no attorney-client privilege, so don't tell me anything confidential at this point. This is the third of our series of 3 kind of legal foundation basics. I mentioned during the first session, I often include a 4th bucket that is regulatory. Whenever I'm talking to any startup, these are the things I touch on: entity formation, structure and finance, third-party contracts, intellectual property, and then I talk about regulatory. Regulatory is really, really specific to whatever you're doing, so hard to create a one-size-fits-all presentation for that. But know that as a startup, you should have that on your radar as well. But today, and right now, we are talking about IP, which I am very passionate about. So why is IP important to you? Well, for most businesses, this is becoming our value proposition in this day and age. According to the World Intellectual Property Organization, and this was 5 years ago, 1/3 of the value of all manufactured products was in intangible capital. So that's intellectual property. Also, there's a moral reason to protecting your IP and to talking about IP. It feels bad when people steal your stuff, and that's going to come up a lot. I'm going to talk a little bit about AI and copyright, and there's a lot of really interesting stuff going on there where authors are like, hey, this is copying my tone. I spent my whole life developing this, and now ChatGPT takes it in 7 seconds. Protecting IP is really smart business. So a couple of great examples, Qualcomm. Everybody in here has a cell phone. In your cell phone, there is Qualcomm technology. Qualcomm does not actually produce anything except ideas, and they license them out, and they make billions of dollars doing so. That is great business. Many of you guys have probably heard of TiVo, or maybe you haven't, because they had a terrible IP strategy. TiVo had a bunch of patents that they did not enforce because they wanted to have industry partners like Sony and the like. And as a result, they lost their patent protections, and they lost their industry share, and now TiVo has kind of gone the way of the dodo as far as I know. Modern Market, I think we might actually be like above one of these, or maybe like one block that way. Has anybody seen a change in Modern Market? Anybody notice anything different?
They changed the name.
From?
Isn't it Mod Market?
It was Mod Market. Good observation. So Modern Market is now Modern Market. It was Mod Market. There's a Mod Pizza based out of Seattle that sells pizza. Now, this is really minor. They didn't have to change too much. They just had to add 3 letters here. But it was literally hundreds of millions of dollars in rebranding and damages that they had to pay, and et cetera, et cetera. So in thinking about kind of getting started, you want to have a good IP strategy in mind, and you want to be thinking about things like that, like your name. And then obviously we got Spotify's logo here. Spotify monetizes a ton of copyrightable subject matter, and they've done really well. So IP is really, really important across a number of different industries, whether you're licensing music, whether you're creating a technology platform, whether you're running a restaurant, or whether you're just licensing out different ideas. This is really, really valuable. Almost every company has some intellectual property, and it drives a lot of value to know how to protect it and to start off on a good foot. So, for those of you who have met me before, I was a teacher before becoming a lawyer. I always start off with an agenda and a takeaway. Today, we're going to talk about internal protections, being patent and trade secret. We're going to talk about external protections. These are items that are facing outward from your company, so trademark and copyright. And then by the end of this, you attendees should be able to describe the 4 types of IP and analyze their own intellectual property and uses of others' IP. I've given this presentation now, like I said, I think this is the 6th year I've given it. And every year, there's a new iteration of something that's coming out, which is interesting. So we'll touch on some of those things this year as well. So first, talking about inward-facing IP. We're going to talk about patent and trade secrets. And so what I mean when I say inward-facing, I mean these are the crown jewels. You're not exposing them to everybody. You're not showing the folks the schematics of the awesome porch lockbox you've created. They actually have the product, but they're not seeing how the VCR works. Trade secret is also affiliated, but a little bit different. We'll get into the nuances of both of them. And depending on what your either technology or product is, one of these might be right for you, or maybe both. So patent. Patent protects novel inventions that are reduced to practice. And what is novel is really hard to determine. It has to be non-obvious. It has to be something that's useful. So one of the most common questions we get is this patentable? And that is a very, very difficult question to answer. It depends what came before you. It depends on how the patent practitioner would view it as being obvious or non-obvious. So if it's an obvious addition, then it might not be patent protectable. It requires a registration. The registration process is fairly lengthy. It usually takes a couple years to prosecute a patent to issuance. And there's 2 stages in that, which I'll talk about a little bit more as well. It is a negative right, meaning that just because you have a patent doesn't mean you can use it. So for example, there's a great Simpsons episode on this. If somebody invents a chair, they can patent that chair. And then I invent 2 legs that if you're leaning back too far, it catches the chair from falling over. I can't use that chair without their permission. They cannot use those catchable legs without my permission. So it's kind of this blocking right. You can block people from using that technology. You don't have to be using it, which is different than other types of intellectual property. You do, however, have to be able to reduce it to practice. So I couldn't patent a time machine when I don't have the ability to make a time machine. I actually have to be able to, in my patent application, write with specificity how you would reduce this to practice, because others are supposed to be able to learn from my patent and then expand upon it. So like I said, you do not need to use, but you need to disclose. Patent, because you're disclosing what it is, you're not allowed to reverse engineer patentable subject matter and just use it. So if somebody makes a VCR and I use the VCR, I keep coming back to VCRs, they're very obsolete. But if I reverse engineer that VCR, I still can't use it. That's not true of trade secret. And so depending on the ability of folks to reverse engineer your product, patent or trade secret might be right for you. So patent is typically right for products that have a really inventive measure and that might become obsolete in 20 years because the protection is only going to last that long unless you follow on with a family of patents. So you think about, we mentioned Qualcomm already with their technology. I mean, how many people have a phone that's lasted for 20 years? 0. Who knows what a dial tone is anymore? VCR, another great example. I keep bringing it up because nobody uses that anymore. So these technological products, which you could take apart, reverse engineer, figure out how to make them, but they're going to become obsolete. That's something that is very eligible for patent protection. 2 things I didn't mention at the onset, which are kind of novel as of the past few years. We're getting a lot of questions about processes, software, and AI. And I would say the jury is out on how all these will be treated. It is typically difficult to acquire a software patent or a process patent as well. If you tie it to a physical product, then it's much more likely to achieve patent protection. But that's not a bar, and that doesn't necessarily mean you shouldn't be pursuing patent protection for these sorts of items as well. So, patent continued. Multi-year registration process. It takes quite a while. As I mentioned, there's sort of a 2-pronged process. You can file what's called a provisional patent, And then you have 1 year, the clock starts ticking, 1 year to file your full patent application. Provisional patent kind of just broadly describes what you're doing in broad strokes. It's not publicly available to start off with, whereas when you file a full patent with the claims, it will tell practitioners exactly how to kind of develop what you're doing, and it will state what you are protecting very explicitly. So why would you file a provisional patent? Well, provisional patent allows you to disclose what you're working on to third parties without a risk of ruining your patentability. So many years ago, I worked at the tech transfer office at CU, and I worked with a lot of medical practitioners. And those folks are professors, they're academics, they want to publish their results, they want to publish their findings. And it was sort of devastating how often that I saw it where a professor would come up with something that was a really cool intervention, maybe a potential cancer treatment, and they'd publish it in the New England Journal of Medicine, or something like that, a prestigious journal. But they didn't have any patent protection, they hadn't filed for a provisional patent yet. You've now just disclosed that publicly. And in America, if you disclose something publicly, you have a 6-month grace period to file patent protection. In the rest of the world, many countries, there's no grace period at all. So you just essentially ruin the patentability of this medical intervention you've created, which is going to take a drug company 15 years to get passed through the FDA. They're no longer interested in producing that drug. So you effectively just killed your intervention. So understanding disclosure obligations is really critical. Anybody who's working on your project should have an NDA, should have a proprietary rights agreement in place. If you're outsourcing your production to somebody in another country, doesn't matter. You still need to make sure you have those agreements in place so you're not killing your ability to patent your own invention. Shifting over to trade secret. Trade secret is for items that may never become public or that are particularly hard to reverse engineer. So it's any information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent value from not being generally known and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So the rumor is, and I don't know if this is true or not, but that nobody actually knows the entire recipe or process for making Coca-Cola. There are different people who know different portions of it, but the actual complete recipe is a secret and has remained a secret for over 100 years. Coca-Cola is able to protect that. When you are hired at Coca-Cola, you acknowledge that they have trade secrets, that they're of significant commercial value to Coca-Cola, and that you cannot take them and leave. And Coca-Cola actually has prevented other people from going to work at competitors based on trade secrets. So for those of you who are here for the non-compete presentation, trade secret is a carve-out where non-competes are actually enforceable. Because you could imagine what it's like if you're a CEO of Coca-Cola and you get poached by Pepsi and you know all of your biggest competitors' secrets. So trade secret's important. Acknowledging trade secrets is important as well. Maintaining secrecy is kind of the gravamen. You don't actually do anything. There's no application to file for trade secrets like there is a patent or anything else like that. It literally is reciprocal to how much you invest in protecting that trade secret. So we work with a number of brewers and distillers. Same with like Coca-Cola. You don't need to tell everybody what your recipe is for Fat Tire. You can keep that in a lockbox, and only the brewers and distillers have access to that lockbox. Need to know basis sort of thing. There was a case where, I put this airplane on there, the efforts are reasonable. So there was a company that was developing a manufacturing facility. One of their competitors hired a private airplane, and I guess now you probably just use a drone, but flew over the property and took a bunch of pictures of what they were doing and then copied it. And the court case basically hinged on what would be a reasonable protection for this trade secret. Do they need to shroud their entire facility in, camouflage tenting to preserve the trade secret protection? And so that reasonable standard is pretty key. You don't need to be doing everything like shrouding your property in, fumigation tents or whatever to prevent your competitors from seeing them, but making sure that people are signing confidentiality agreements, making sure your sensitive information is password protected or in folders that are not accessible by your whole company. These are really good ways to protect trade secrets. And like I said, it's not 20 years like a patent. So if something's not going to go obsolete, like Coca-Cola or Bush's baked beans recipe is apparently the same deal, you can protect it for as long as you maintain it as a trade secret. Yeah.
Quick question, the fourth bullet point. Do you see that as being the biggest difference between, is it
Yep.
with a trade secret, do you see that is possibly one of the biggest disadvantages compared to patent protection? That's
Yeah.
question one. And question two is then, what's the biggest drawback with patent compared to trade secret?
Yeah, good question. So,
No client lawyer privilege.
no. So,
Mindful of that.
reverse engineering a trade secret is a big drawback, right? Like, somebody could probably run a spectral analysis of Coca-Cola and figure out exactly what it is, and I mean, they probably have in some capacity. If you Google it, it'll say it's still a secret. And obviously they have a big brand play, and we'll get into trade dress and brand names and stuff as well. But yeah, that is a significant drawback. The drawback of patent is the limited temporal protection. So like, I mean, we talk about drug companies. Drug companies obviously use a lot of patent. Why are there generics? Because the patent expires and then somebody can just make it generic and sell it for pennies on the dollar. The other kind of issue with patent is it's relatively expensive to pursue a patent, and you don't know whether your invention is going to be profitable or not. So to dump a bunch of money into a patent that might be worth absolutely nothing can be kind of tough.
So you're looking at basically how tough is it to reverse engineer? And if it is really tough to reverse engineer, then possibly consider trade secret over patent.
Yeah, absolutely. How tough is it to reverse engineer? And also, how long is the value going to be preserved by having this be a secret?
Right.
So, if it's going to be some piece of technology that becomes obsolete within 20 years, go for the patent, But Coca-Cola obviously has lasted the time. So, I mean, if you look back at you can kind of see what companies are doing this sort of stuff. You have hardware, pharmaceuticals, Qualcomm, kind of more like tech-heavy companies, whereas recipes oftentimes are protected by trade secret. And you can actually file a patent on recipes, which is very atypical. You don't see it very often. The other thing about patent is that you can work around patents in certain ways. So, for example, with a recipe, you would have to state very particularly it's a carbonated beverage with sugar amounts between X grams and X grams. And if you just kind of tweak the recipe so you're not reading directly on those patent claims, you're no longer infringing. Yeah, good question.
Oh, sorry.
There you go. So the difference is length of protection certainly is a significant difference. Trade secret can last forever. Patents not lasting more than 20 years. There are some caveats to that, and what you see, especially with drug companies and mature companies that have developed a really strong patents philosophy, is that they'll roll out a family of patents. So you see that they have, Prilosec, and then they have Prilosec that's extended release, and they file a patent on that a little bit later, and then so they kind of roll out this family to just create this moat that lasts indefinitely, which is somewhat true of copyright as well. And Disney has been really good, I guess, at that, even though I have mixed feelings about it personally. Patent versus trade secret again, ability to reverse engineer. Trade secret, you can reverse engineer. Patent, it's a negative right, doesn't matter. I've already given you the instructions to how to do this. You can't do it for 20 years. Both require discretion. Disclosure is really key. And it sits near and dear to my heart because working at the technology transfer office, you'd see these folks who dump their lives into certain research projects just to kind of immediately throw them away by publishing their results, which they thought was really good. And they'd kind of been told was really good. And they could have if they'd just waited a little bit longer and filed their provisional patent first. So consider which is right for you. What are you creating? What is your competitive advantage? Is it temporal? Is it easy to reverse engineer? What is your cost sensitivity? And that is really kind of where to think about your internal protections, patent and trade secret. So now we can talk about outward-facing IP. And this is kind of your brand or your product that you're putting out that's consumable. So we're going to talk about copyright and trademark. So copyright. This has been probably the most dynamic portion of this presentation over the past 5-6 years. It has changed so much and continues to. I mean, even as of yesterday, I was just reading about some pretty dynamic changes in the copyright landscape. Copyright applies to creative works fixed in a tangible medium. So right now I see a lot of you guys taking notes. You have copyright in those notes. You're writing it down, it's creative, it's your own fixation, and that is a common law right. So even though you haven't registered copyright, you have rights in that. To enforce that right, you need to have a registration, but you still have rights in whatever you're producing. It's made to incentivize creation and provides a limited monopoly, a lot like a patent. So I create this creative work, I disseminate it, you can't just go and photocopy it and sell it because we're trying to incentivize artists and designers to create new things for public consumption. It protects the heart and soul of creation. And things are going to get really, really interesting here because how we define that heart and soul is going to change depending on what is creating the output and how broad that heart and soul is. So infringement is, and I'll talk more about this in a couple slides, but it's based on access and similarity. So there was a bunch of cases against like the Beatles where somebody was like, oh, I wrote that song in my basement before the Beatles wrote it. And there's like 4 chords or something that 95% of all songs are composed from in your 1-4-5 voicing. And so there's a lot of infringement cases like that you see. And the courts will say like, look, man, the Beatles were never in your basement and you've never released this song. And so there was no access. So even though the similarity is very similar, there's no infringement. So the lower the access, the higher the similarity has to be for there to be copyright infringement. The lower the similarity but higher the access, if there's great access, then there's more copyright infringement. So you hear about this in like these big sexy cases, Robin Thicke and Marvin Gaye, Vanilla Ice and David Bowie, under pressure there. And these are all like high access, high similarity cases. More often, it's kind of like small and a pain in the butt, and we'll talk a little bit about copyright trolls and the things that are happening right now, which are really dynamic, once again, since I gave this presentation. One other thing, kind of on this broader perspective, we talked about patenting software and how it's a little bit difficult. Doesn't mean it's not worthwhile, it can be certainly. Another avenue is to protect your computer code by registering the copyright in the code. So nobody can steal your code. And there's a lot of interesting work being done right there. Technically, it only protects the fixation of the code as it is. So if you can code this same thing in a different way, then you might be able to get around that. But once again, we come back to access and similarity. If there's similar type of code and you have a really prolific piece of software that's on everybody's computer, a finding of infringement would be more likely. So there's kind of a couple things to consider. There's creators in here who are creating copyrightable material, and there's consumers in here who are consuming copyrightable material, and oftentimes you might be doing both. And there are different considerations on each side of the fence. So what you should do with your own creations. As I mentioned, copyright is a common law right. So your notes have copyright in them right now. But if I went and photocopied them and you tried to sue me for it, it would immediately get thrown out unless you had a copyright registration. And then you can come and claim statutory damages. There's a lot of benefit to registering your copyrights. It's relatively quick and easy. It's like a $65 fee. If you have a lawyer do it, it's a bit of lawyer time, but it's honestly, I think, probably 20 minutes, 30 minutes of our paralegals' time to put together a copyright application. It takes a long time for these to register, though, typically around 8 months. And so kind of doing it early and often is good if you're a content creator. Yeah, go ahead.
Are they backdated from when you file?
Yeah, good question. The date of filing is your date of registration if the registration should issue. And the registration entitles you to statutory damages, which is really, really important when you're trying to bring a suit for copyright infringement, because otherwise you have to prove what your actual damages are. And unless you're licensing out that photo all the time, or that's really like the thrust of your business, it's really hard to say like, oh, this guy stole my blog and put it on his website, and now I'm damaged to the tune of $1 million. How did you come up with that number? And that's what the fight becomes, is what are the damages? So if you register your copyright, then you're entitled to statutory damages that can range up to $150,000 per incidence of infringement. And that's going to be critical when we talk about copyright trolls here in a second. But the other thing to note is that The $65 fee is for regular processing. You can file for expedited handling, but then it becomes an additional $800 to file for that. And it takes about 2 weeks usually, week to two. They look at those applications much more stringently. So the only copyright applications I've ever had rejected have been ones that we filed on an expedited basis. So you also,
If you're protected from the data filing, why would you expedite?
because you haven't filed. So I take those notes that Laura's writing in the front row right now, photocopy them. She hasn't filed on it. I disseminate them. She needs to have a registration in order to be able to bring suit against me. So you file, I'm seeing some confused faces. I'll go further down the hole on this then. You cannot file a lawsuit for copyright infringement without a registration. So you have the rights, but you need to go like to the Copyright Office and register those rights in order to bring a suit. That registration process will take about 8 months. And in the meantime, those damages would be accruing. So if Laura wants to sue me for stealing her notes, and she doesn't want to wait until her registration issues 8 months from now, she's going to file for expedited so she can sue me next week.
Isn't there a thing that if you just start putting the copyright symbol on there, that it gives you protection?
That's a good question. It is best practice to put a copyright notice on there. There are different damages that you're entitled to based on willful infringement or sort of accidental infringement. So if I put this copyright notice on here, then there's a presumption that if you take it, you are willfully infringing my product and I am entitled to greater damages. This doesn't actually afford me a registration. I still need to go through the copyright registration process. And yeah, so it is best practice to do that, but it's not going to be the dispositive factor.
So in this instance, are you registering this slide, or like what are you registering?
Good question. I could register any of it. I could register a compilation. We put together 3 presentations today. I could register all of those as a volume of works. There's many, many different ways to register copyrights. One of our clients does a ton of social media advertisement, and they work with a bunch of content creators who are constantly putting out these pictures. So for those of you guys who were at the contract presentation, there's contracts with those content creators that the images they create using our client's product belong to our client. They get ripped off all the time. So we basically have a monthly kind of photo dump where they give us a bunch of photos that we register as a volume. And I think we put like 100 in each copyright application. But you could register a copyright with just one photo. So really depends. We could register the entire presentation. We could register all 3 presentations. I could register just this slide. Depends on where my value proposition is.
Yeah, because I'm thinking like if you have a website and you're doing content creation in the form of like blog posts, like how do you copyright that?
Yeah, good question. So I would say, you can copyright the blog post itself. You could copyright the design of the website. You could copyright the entire compilation of blog posts. I think it's really kind of a value proposition as to how much that's worth to you. Once again, coming back to steering the heart and the soul. If I registered the copyright in this entire presentation and somebody took one slide from it, it would be a lot harder for me to argue that they stole the heart and the soul when they took one slide and put it into their much bigger presentation. Whereas if I just had the copyright registration in this one slide, they stole the whole slide. They took the whole thing. That's the heart and the soul.
Now, let's say you did try to copyright this presentation. Would there be copywritten information in the presentation that you kind of run into issues with? Like you were showing the Coca-Cola logos and stuff like that.
So when you file for copyright, you have to basically state what the pre-existing materials were. But you can have a copyright in a compilation. So you think about like a textbook where a different professor wrote each chapter. The professor can have the copyright in the individual chapter, whereas the publishing company can have the copyright in the compilation of all of those chapters put together. So there's multiple copyright, and kind of like patent, I am the publisher of that textbook. I can't use those professors' portions without their permission, but they can't disseminate the textbook without my permission. Good question.
If I understand correctly, like I could take the words from those slides
So within reason, the more creative a work is, the less ability you have to just kind of like take from it. So like going back to textbooks. You can't protect the idea of algebra. But if I write a textbook in algebra, I'm protecting the fixation of how I'm presenting those ideas. Now, if you went out and read my book, and then you made a new algebra book that was very different but had the same ideas, I can't protect the ideas, but I can protect the fixation. The more creative it is, the more protection you have, the more kind of leeway you have in that.
Or general facts.
Yeah, right. And there's also like a de minimis doctrine. So there was an instance where I think it was Tide or Procter & Gamble had like a competition where they put their, no purchase necessary to win and yada, 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 kind of legalese. Another company sued them for stealing their kind of competition language. And the court was like, look, there's like 3 ways to say this, man. You can't own the competition language. Go pound sand. And I'm sorry, you had a question too.
Just quick, like the textbook thing, you can quote from it, not in like fair use, isn't there a fair use?
So fair use analysis is super nuanced, and I would say the most important factor in considering fair use analysis is what the purpose of it is. So if you're using it for an educational purpose, for a news purpose, then you're going to be much more likely to be deemed to be using fair use, especially if you're just using what's necessary to kind of convey the idea. There's going to be some slides on here that I'll come back to that on. I didn't particularly address that, but there is potential for fair use depending on what the nature is. The more commercial the use is, the more you're making money off of it, the less likely it is to be fair use. Good. Yeah. Yep. Yes, sir.
So I've done software for a long time, and often we use open source libraries,
Mm-hmm.
and they usually have something called an open source license. MIT is the most famous one.
Yep.
Is that talking about copyright?
Absolutely. Mm-hmm. I mean, it could be talking about rights beyond that, but yes. And those open source licenses are really interesting and nuanced because there's many different flavors, as you know, and they'll get into the uses that are applicable for that, where you don't have to pay a royalty versus ones where you do. And
So instead of the open source license, you put in something that's just proprietary enough?
if you don't want it to be open source?
Yeah, if you're writing your own code.
Yeah, I mean, you just don't open source it. So many of the open sources, you're submitting it to a particular database that has licensing terms. And so like the Creative Commons has particular terms. There's, I want to say 4 different levels of Creative Commons licenses. Yeah, and each one requires a different level of attribution.
We had one situation where we were going to use with the advent of all these front-end frameworks, some of the larger companies have open source some of their code.
Mm-hmm.
But in one of these cases, they didn't open source everything. There were a few things that we wanted to use that were considered proprietary. We couldn't get them to say, so we left and went somewhere else.
Yeah, I think that's a good call. There's a lot of traps, and there's a lot of really unscrupulous folks out there, and this is growing in a very profound manner. From the first time I did this presentation to now, I would say we see probably 100 times more copyright infringement allegations than then. It has really proliferated for a couple of different reasons. And finishing up this slide, for what you should do for your own creations, register your works if you're worried about somebody taking them, because doing it early is inexpensive, entitles you to statutory damages. If you do it later, you're going to have to wait, and you're not going to get statutory damages. It's going to be worse. So if you're a creative who's really an artist or creating a magazine or something, consider that. This kind of relates to exactly what you were talking about, that Creative Commons licenses often require that you give attribution in a certain way. It's not always really clear what those are. People will intentionally hide the peanut so that you miss the attribution, and then they come at you and say, you owe me $50,000. Yeah. Make sure you're giving appropriate credit, and then be really deliberate about what you're giving to others in contract. So we work with a lot of web designers, for example. There's a lot of templates that people use to create websites that they might want to reuse over and over and over again. What you're delivering is the final product, and you have no problem with the client taking copyright in that final product, but those underlying items you might want to have and retain the registration in. And this comes back to kind of your question as well, which we could go down the rabbit hole on derivative works, but if somebody is making a work based off of your work, it is technically a derivative work. Depending on how departed it is from your work, they might have independent copyright protection, or it might be subject to your permission. So this came up with, I want to say Rocky 3 or 4. Somebody watched the first couple Rockies and then preempted and wrote another Rocky video or movie, which really read on what Sylvester Stallone actually ended up creating, but like, how different is it going to be? There's a boxer, there's another boxer, there's some drama, there's probably a love story involved in some way. And so then that guy was like, Sylvester Stallone, you can't make Rocky 4. And he was like, no, you actually made a derivative work of my product. You don't own this. I do. You lose. And he won. So, Adrian. So I mentioned before, infringement is really based on similarity and access. There's also an aspect of creativity here. So this came up with a form book for a bunch of accounting forms where somebody copyrighted that form book. And so they had copyright protection on the fixation of the forms, the layout of the forms. But if somebody else kind of like changed that a little bit, they weren't going to get infringement, even though access and similarity were high. So, you know, it kind of like streams outwards based on creativity as well, and there probably should be another axis here with creativity on it. But greater the access, the less a similarity has to be. And if there's no access, then the similarity has to be pretty profound. Ostensibly, if two individuals created the exact same thing without knowing of each other's stuff, it wouldn't actually be copyright infringement. Kind of an interesting fact. So we talked about what you should do with your own creations. Make sure you register them. Make sure you're attributing appropriately if you're incorporating other stuff into your work. You can put that copyright notice on there that you mentioned, which I had on the other slide, which entitles you to heightened damages. But what you should do with other creations is critical. And you know, like I said, 6 years ago, this slide was not as important as it is now. Be really careful. Don't make assumptions. The CC BY Creative Commons licenses are a great example. Make sure if you're pulling something from another website, you know that you have the rights to use it. There's this company now, Pixie. Anybody heard of Pixie? I would say our clients receive at least one letter a month from Pixie. It is a copyright agent, essentially, that agglomerates everybody's rights to enforce their copyright in images. And then it just trolls the internet and finds where you have an image that has been posted without a license, and then it automatically generates a cease and desist letter and sends it to you and says you own or you owe anywhere from $3,000 to $10,000 to $50,000 based on putting that image on your blog.
So if you're using like a content management system and they provide pictures that they're like, we've licensed these for your use. Are you exposed or are they exposed?
That's an excellent question, and it's, I don't know if you were at the last presentation, but this has come up multiple times, including as recently as this week in my practice. It depends on what your contractual engagement is with that provider. So, real life example, we represented a client who hired a third party to write a marketing blog. They did so. They pulled a picture not so dissimilar to this. Very benign picture of, I think it was like a contact lens case or something on a bureau. And they didn't have rights to that picture. And so the practice, who had outsourced this blog to a third party, gets a claim. They didn't even get a cease and desist letter. They just got served with a lawsuit. The person had registered the copyright in that. It was pretty classic copyright troll behavior. And they brought the lawsuit against our client. And we said to our client, well, do you have a contract with this third party? And they said, no. And then they provided us an invoice. And at the bottom of the invoice, it says, you agree to our standard terms and conditions. That is a contract. We click on the standard terms and conditions, and it said, you, the client, are explicitly and solely responsible for what we, the web developer, put onto your blog. So technically, under the law, our client was responsible for this, and it was, a statutory violation of this copyrightable subject matter. More practically, we went back to that blog creator and we said, look, this is a ridiculous term to bury in a contract like this. You work with a lot of other companies like this. I don't think you want this getting out and for everybody to know that this is the way you do business. So let's talk about how we're going to deal with this. And in the end of the day, they ended up splitting the damages, which was, it wasn't a huge amount of damages, so it was somewhat palatable. But in relation to your question, you need to read your contracts and you need to read those terms and conditions to determine what rights you have and what you don't, because you shouldn't be responsible for something that somebody else is putting on your website. Going down the rabbit hole a little bit here, but my philosophy as an attorney is start from fair. And if you're the one creating the product, you should be the one saying it's my responsibility to ensure this isn't infringing. But not everybody operates that way. So, good question. If there hadn't been a clause in there, they could both be liable for it. Yeah. So yes, Pixie, reverse trolling, basically. They're just scanning the internet. And they represent all sorts of companies like, they have 200,000 plus clients now. The New York Times is one of them. So if you're pinching an article from the New York Times and you put it on your blog, Pixie very well might find you, and then you're going to get hit with a letter that says pay us. Go ahead.
So in terms of protecting myself, if I'm going into Shutterstock, Motion Array, any of those sites that allow me to use their assets, should I download their terms and conditions, save it, have my contract? Like, what evidence do I need to prove that that photo I took or that content that I have the rights to?
Good question. That's exactly what you should do. Buy the license, download it, keep it. And then if somebody comes at you with a letter, you say, here's my license. And make sure you understand what that license entitles you to do. 1 second. So this actually came up with us. When we first started creating our website, we hired a design company to create our website. They said, we'd like to get headshots of you. We have this photographer we work with. He's great. Cool. Photographer sends us a proposal, and it says, I'm licensing you these photos that I'm taking of you for use on your website. And I'm an intellectual property attorney. I was like, I need to own these photos. And all this was done through the graphic designer intermediary. I never actually had contact with the photographer. So I said to the graphic designer, no, this is unacceptable. We need to own the photos. So she reaches out to the photographer, who writes an email that she forwards to me, which said, I do not sell full right and title to my photos because copyright infringement suits are very lucrative for me. So he was licensing me these photos to put on my own website, but if I put them on my LinkedIn page, that's not in the purview of the license he just offered me. So we went with a different photographer. These are kind of like the little traps that people bake in. I mentioned the CC BY. It will tell you in the license what to put, but sometimes they bury it. And then they'll look for you to mess that up. And then you pay $10,000 for a picture of a contact lens case that you could have taken on your iPhone. So you just got to be pretty careful for these. Read your contracts, website terms of service. I use a lot of Unsplash photos because they're just open and please take these. So that's where most of these have come from, Unsplash. I also am kind of relying somewhat on fair use on some of these because I feel like this is an educational presentation. And also coming back to the what are you taking? I'm talking about Pixie. I'm using Pixie's personally posted graphic here. There's a strong argument that, how can I talk about Pixie without that? If I'm selling an iPad, I need to say I'm selling an iPad, even though I'm using that portion of their intellectual property. So de minimis doctrine.
I have a question. So news organizations in the past, if you were writing a story and there was something that some other news organization got first, you would give them credit, and that would be in your story. And is that still they can do?
That's a good question. I think that with news, there's a fair use argument basically all the time. Anything that's newsworthy is fair use. I'd say it depends on kind of what you're taking from the other individual, but I would guess that that's kind of waning because the news organizations don't seem to like each other very much. Probably don't want to give attribution.
I broke the first rule. I incorrectly made an assumption that we would have Q&A at the end, but I just want to make sure that we're going to have time to go back and talk and ask
Yes, good question, and the answer is yes. And you didn't break the rule. I broke the rule because I said there would be Q&A at the end, and then I took them. But I can hang around afterwards, too, and I don't think there's anything after me. So I'm glad that you're getting value from this. And I'll keep moving on, too. So this is a new slide for this year. Copyright in the world of AI. And all of this is like the wild, wild west. There's been very little that's actually been determined as of yet. So you got new platforms, everybody's sort of ChatGPT and OpenAI, DALL-E, Midjourney, Creativity Machine, Stability AI, that, you put in a prompt, make me a picture of XYZ, and it spits it out. Make me a poem that sounds like Jack Kerouac about Nikola Jokic, and it spits it out. I actually did that one once. And it's pretty compelling. I don't know how many of you have had an opportunity to play around with it, but it's pretty impressive what we're going to be able to do here in very, very short order. It's grown by leaps and bounds, and we're going to have computer code that is created by AI. Make me a program that cooks my toast, whatever it happens to be. So there's a lot going on here relating to copyright. So we create prompts, it generates AI. This is actually an AI-generated portion of art that was created using Creativity Machine. It is called A Recent Entrance to Paradise. This guy, Thaler, made Creativity Machine. And then he tried to get a copyright registration on this piece of art, which he put in the prompt, and it spit out that piece of art. The Copyright Office rejected that wholesale and said, artificially created works are not registrable. There is no copyright protection in artificially created works. And there's some really interesting kind of questions that come out of that as well. What is copyright protectable? Well, arguably the prompt. The engineer, the prompt engineer wrote in what to create. So there's a lot of value there. And I think a lot of people get really intimidated, lawyers and creatives as well, about what AI is going to do. But you have to have the knowledge and skill set to engineer those prompts, to create something that's valuable. Our graphic designer was talking to me about kerning, something I know zero about. And he showed me, he's like, oh, look how much better this looks. And I can tell you, that looks better, but I can't say it looks better because it's in this font with this typeface and this kerning and this color, this Pantone. So this is a bit off topic, but I think there's going to be a lot of value in creating prompts, and I think there will be copyright protection in those prompts themselves. But as of right now, you can't actually register the final output. This has been appealed to the federal circuit. So essentially this guy went and sued the Register of Copyrights and the director of the Copyright Office, Shira Perlmutter. The federal circuit sided with the Copyright Office, but they sided with the Copyright Office on what's called an arbitrary and capricious standard, meaning that they're going to defer to whatever the Copyright Office says unless it was an arbitrary and capricious judgment. So really what this means is we're deferring to the politicians to come up with a way to regulate this, and when the administrative bodies like the Copyright Office say it's not registrable, we're going to go with that until the legislators say it is or it isn't or whatever it's going to happen. And that's going to be real interesting because there's a lot of people on there that probably have no idea what AI is. So a couple more examples. So this is all kind of what's copyrightable from the output standard. There's also some really interesting stuff going on right now from the input standard. So AI is basically scraping stuff from the world around you to create something new. So it has access to all this stuff. So Getty Images and 3 other artists are suing Stability AI and Midjourney, claiming that all of the works that they create are infringing Getty Images copyrights because they scanned all of Getty Images images to create new images. So then we come back to that access plus similarity. Access, very high. They literally scanned all your images. Similarity, probably not so high. It's making something really new and unique. And does it matter that it's a machine that's making it? Does that change the heart and soul that's being stolen? Does it limit that? So I think this area is fascinating. We're just at the tip of the iceberg here. None of this has really been finally ruled on except for, this upholding deference to the Copyright Office to make their own decisions. So we talked about copyright for a while. I appreciate it. It's super interesting. Trademark is the other sort of outward-facing intellectual property. It's any word, design, trade, dress, or sound that indicates the origin of the goods and services. And the reasoning behind trademark is to provide consumers assurance of quality of the product. I know when I'm buying a Kirkland brand sparkling water, it's going to be fantastic, and I'm going to get 40 of them at the same time. It's preserving that integrity of the brand. And yeah, it extends to all sorts of things like D. Anybody know what TV station we're watching? NBC. Those are the notes G, E, and C for General Electric Company, which is the owner of NBC. So anything that insinuates what you're doing, what restaurant are we in here? Chipotle. You're in there, you know you're in there, that's trade dress. Shape of a Coke bottle, trade dress. So we usually think about it in terms of brand names, but it can extend to so many different things. So Milgram and Dascom is trademark. You know you're going to get great legal services when you come to us. Denver Startup Week is trademark. You know you're going to get an awesome experience. Chipotle, the inside of it, NBC tones, obviously logos, and then another version of trade dress right there. That's obviously the silhouette of a Coca-Cola bottle. Purposes to assure quality of the product. The gravamen of infringement is a likelihood of confusion. So I hear people say all the time, like, oh, I changed 2 letters and it's Nike with 2 Ks in it now, and I'm going to make shoes. No, you can't do that. If there's any likelihood of consumer confusion or potential for consumer confusion, then that's trademark infringement. You can't be pirating on the goodwill of another company. Yeah, that's a whole other can of worms. It's a common law right. So if I start John's Burgers on the corner outside right now, I'm technically accruing trademark rights in John's Burgers outside. However, it's very hard to enforce that right at common law, and it is geographically limited and limited to the goods and services I'm actually providing. So if I start John's Burgers outside, I might have trademark protection on the corner here for my burgers, but I wouldn't have it certainly in Florida. This actually came up with Pixar, where there was a movie rental company in Florida called Pixar, before the Pixar that you guys all know, and they had to settle with them. Comes up with all the sports teams that are rebranding. Eskimo Pie is about to rebrand. That's going to be an interesting one. But federal registration confers on you the presumption of seniority throughout the 50 United States. So it's pretty important, because otherwise, if there's, we represented a trucking company. There was another trucking company that was east of the Mississippi. We were west, and they had the same name, to the point where they were actually getting each other's shipments of like large semi-trucks. There wasn't just a likelihood of confusion, there was significant and serious confusion. Because we hadn't registered, they were able to claim prior use in that section of the United States. So now, like, we've divided the United States. Trademark rights are jurisdictionally based, so you'd have to register in other countries, and the reason I bring this up is another example is Budweiser in the Czech Republic is not the same as Budweiser in the rest of the world. Budweiser in the Czech Republic that you know here is called Budvar, and Budweiser there was another beer that was created called Budweiser, which is a different Pilsner. Is it? I've never had it. Good. One thing to note here is not all marks are created equal as well, so if you're naming your company, some things to think about are how descriptive is the mark, how generic is the mark. There was a restaurant in Boulder when I was going to law school there many moons ago called Cafe Food. That is not a protectable name. That is definitely on this end of the spectrum. Whereas something that's more arbitrary or fanciful, Amazon. Amazon in no way describes an online warehouse where you can buy absolutely everything. That is much more protectable. Your rights are going to be much larger in that. So if you're starting a company, a couple things I'd consider, a knockout search, that's actually searching the trademark office's database to look at what exists. Definitely Google your name. Somebody came to me and they were like, I want to start a camp called GoPro Lacrosse. And I was like, I think that might be taken. So the test database, paying for a knockout search from an attorney or from a third party is a good idea. And then considering adding distinctive elements. The more elements your mark has, the more likely it is to get protection, logo or a tagline. Disclaimers are related to this spectrum where if a portion of your mark is generic or descriptive, you can't claim ownership in that portion of the mark. So if I file a trademark application on Applebee's Restaurant and Grill, I can't protect restaurant and grill. I have to disclaim restaurant and grill. And that has some perverse outcomes. I had a mark for tacos rejected by a mark for wine because I had to disclaim tacos. So it was like going to a taco bar versus going to a wine bar, which are not easily confusable. We were able to overcome that rejection, but it's just an interesting kind of practice point, I suppose. Yeah, so I could talk for a lot longer about trademarks or anything, but I want to make sure we have time for questions, and I appreciate your calling me out on that. So before we move on to the question and answer session, just a couple checks for understanding. As I mentioned, I'm a teacher, so we always end with pop quiz. Can anybody tell me the two types of internal IP protections? Patent and trade secret. Patent is your limited 20-year monopoly to inventions, no reverse engineering. Trade secret, unlimited as long as it's a secret, but you can reverse engineer it. Can anybody tell me the two external IP protections we talked about today? Copyright and trademark, thank you. Yes, copyright, be careful of the traps, protect yourself, contract appropriately, register your material. Trademark, origin of goods and services, search before you start your company, and register for significantly enhanced rights. So your assignment to take home is to think about what IP you have in your quiver and how you can best protect it, hidden behind this mountain. And with that, I'll take any questions.
Do you have patent monitoring software?
We do not personally, but many companies do.
So does it monitor people that are searching your patents, or is it looking for similarities?
Patent monitoring software is pretty nuanced. More common would be copyright or trademark monitoring software, where trademark monitoring software actually monitors the register where goods and services or where marks are being published. Copyright kind of like Pixie scrolls the internet and pulls from there. Yeah.
So, like, going to copyright, how much do you need to alter the
Just enough. Yeah, I mean, I don't think there's necessarily like a bright line answer to that, which makes it kind of difficult. But once again, access and similarity. So that's a very famous song. The similarity doesn't need to be that high for there to be infringement in that instance.
So going back to copyright, so like everybody's putting the copyright symbol and everything they do, websites and everything. But technically you said if it's not registered, it really doesn't mean anything, right?
It means something because it can constitute a claim for willful copyright infringement, which can enhance damages if you are to bring a lawsuit later.
You register it later.
Right. You'd still need to register to be able to bring a lawsuit, though.
Yeah.
Yeah, but it is best practice to put that on there. I don't have it on here. Yes.
Another question about writing songs. So I know, like, my daughter's writing songs for a EP, so she's sharing her songs, and I'm asking her about, copywriting. What if you're in the process of creating a project like that? What do you need to do before you share?
Sharing it's not that big a deal because you have copyright that attaches at common law. So technically you already have the rights. If you wanted to sue somebody for those rights, you need to register them. So yeah, short answer is you don't need to be shy about sharing your copyrightable subject matter. But if you're worried that somebody's going to take it, then you might want to register the copyright in it. And music is particularly interesting because there's a couple different layers of copyright. You actually have like the fixation in the sheet music. You have a fixation in recording. So there's different layers of copyright in a musical production.
Would you then suggest that the project is finished before
I mean, that's a good question. I think it depends on how concerned you are that somebody's going to take it. So, you know, you see software companies release a new version of their software every so often. Maybe they copyright it once a year and they release a new version every 6 months. There's always the question of like the Sylvester Stallone Rocky IV, is it a derivative work? So if you're wholesale making changes, you definitely want to register a new copyright. If it's just small little things, it's likely protected under the prior registration.
If you're using somebody else's beats and stuff like that, then you have to make sure you have the license for the music that you're using?
Yep,
Okay.
good question. Thank you.